For judgment, item number 1.
The present intra-court appeal is found to be devoid of any merits and it is deserved to be dismissed. It is accordingly ordered.
For admission, item number 2.
Any affidavit file?
Yes.
Yes, permitted by his honorable court by filing affidavit yesterday also. I think it was the cancellation of the agreement was voted on 12th September. Also, you'll find it page number 16 of the agreement. Next page, we have also totally the bottom of the very government of India. Cancellation.
You can issue corrigendum, dropping that clause or revise that cost. Because it is up to you. You know what is the contract agreement. It is terminated or going to be terminated. It depends upon that. Yes, anybody? Yes.
The lawsuits, the NIT dated 28/8/2024 issued by the respondent in the charges here, which the lawsuit by doing away with the NIT dated 12 September, now 28 cents. As my lord has correctly expressed the lawsuit's opinion regarding the corrigendum for the most risk and most aspect of the lawsuit.
It is to the discretion of the NHIDCL.
The lawsuit-
I have just indicated that
My lord,
it can be done. That if they decide to proceed, they can revise the estimated cost by dropping the risk and cost. You want extension, there may be possibility of extension. Okay, reserve liberty would be reserved to the NHIDCL to extend the period for 7 days. Right? Yes, I indicated to you, that is the likely, yes.
I think, my lord, since this is a public interest litigation and the road is in such a situation, the law, unless the referendum is issued to the aspect of cost, risk and cost, upon the contractor, if that is allowed to proceed, the law, it will again lead to further litigation challenging that NIT again the road. So if, since in my affidavit dated to the 4/9/2024, as well as the affidavit which I filed yesterday, we have also raised a question on why at the risk and cost of the contractor. Because there is a contract provision, article 23.2 also, which says that we are saying that it is by their default. They are saying it is at our default.
Dispute resolution is not the purpose of PIL,
Yes, my lord.
not in the realm of PIL.
I-
Dispute resolution,
Yes.
intra-party dispute, that falls in
Yes, sir.
realm of private law. It is purely the contractual arrangement between the NHIDCL and the contractor. We are not concerned with that. We are concerned with the commuters at large, public at large. Now, when we found that the act of issuing a parallel NIT
Madam.
suggestive of an act of contempt, we have observed yesterday.
Yes, your lord.
Now they have acted on it, expressing apology, they have cancelled the
Madam.
NIT. Now, the matter will be proceeded with as per the original NIT. Now, if they want to drop the risk and clause, cost clause or not, what is the contractual arrangement between you and the NHIDCL? We are not concerned with that. Now, if things are amicably decided, they may drop the risk and cost clause from the NIT dated 28/8/2024
Your lord.
and may issue a corrigendum. It is up to them. We are not sitting here as advisor. We want to know that somebody hampers or puts a block in the construction of the highway. We have to see that, and we have to come hard on whoever is putting a roadblock in the road. That is all.
Hence, that is why I was sharing my concern with my lords. They kindly look in that aspect, because if the road is not constructed.
That is what we are concerned with. Tender should be, process should be brought to a logical conclusion at the earliest.
But if we challenge it again, will it go ahead?
You challenge.
That is up
I
to you.
cannot stop. I cannot stop Mr. Seki from you. Everybody has a right to seek legal remedy. We cannot bar. No, we are not here as advisor. We are not here. We do not take the advisory role.
Correct.
Whoever files a petition, we decide that. That's all.
But people notes may kindly report my submissions for that matter.
No, that is not going to be recorded.
No.
This is out of the PL, scope of the PL.
Yes, sir.
This is intra-party dispute. If you have any grievance, you brought it before the NHIDC. You go there and say that drop this risk and cost clause. That they will decide. Okay. Hard repeat, huh? Previous order. Moaz Amir, NHIDCL, so and so, Imti Imsong, Joshua Seki, Sentia Anger, Lucinio. One, para two repeat. Pursuant to yesterday's within bracket 3/10/2022 order. Mr. Jamir, learned counsel for the respondent number 2 and 8 stroke NHIDCL authorities. Pursuant to yesterday's order, has submitted that pursuant to yesterday's order, an affidavit for on behalf of the respondent number 2 and 8 stroke NHIDCL has been filed today. Full stop. Sopera, Mr. Jamir. Learned counsel has submitted that has expressing apology regarding the mistake committed inadvertently in initiating a fresh NIT, notice inviting tender, dated dated 12/9/2024 for the same stretches of for short-term maintenance contract of NH 39 within bracket new NH 02 bracket close from Kohima to Mao for the same stretches which are included in the previous two NITs, both dated 28/8/2022. The NIT dated 12/9/2022 has been annulled by cancellation notice dated 3/10/2024. And consequently, the bidding process for the subject for the work for the short-term maintenance contract of NH 39 within bracket new NH 02 for the same stages of work would not be proceeded further. Full stop. In the affidavit filed today, it has been stated that the two NITs which were floated on 28/8/2024 with the incorporation of the risk and cost clause of the EPC contractor, is scheduled to open on 17/2024. Full stop. Having regard, it is further stated that it has been further stated that the respondent NHID sale authorities it is further stated that the situation may arise for the respondent NHIDCL authorities to extend the time period for submission of bids by another 7 days till 15/10/2024, so as to enable them to complete the tender process on time, and the same might be necessitated to address the maintenance works of the concerned stretches of the highway which has become precarious in view of large potholes. And to bring the road to a safe and operational condition for the safety of the commuters and to the public at large. Full stop. Para. Having regard to the observations made in our previous order dated 3/10/2010. And for the fact that the respondent NHIDCL authorities have cancelled the parallel tender process initiated by NIT dated 12/9/2024, by a cancellation notice dated 3/10/2024, we are of the considered view that we accept the apology tendered in the affidavit. Full stop. We are of the considered view that the respondent NHIDCL shall proceed with the tender process initiated by the two NITs, dated, both dated 28/8/2024, to bring the same to its logical conclusion at the earliest. Full stop. As it has been expressed that to bring the two processes, tender processes to its logical conclusion at the earliest, in a proper manner, the respondent NHIDCL might require to extend the period of submission of tender by 7 days up to 15/10/2024, we find it proper to grant such liberty to the respondent NHIDCL. Full stop. It is expected that by the next date of listing, the respondent NHIDCL, no, it is expected. Full stop. Next para. Yes, probably. Yes, tell me when you can come up with your some status regarding. We'll put it on 23rd. 23rd. 23rd October. Yes. Lays the case on 23rd October 2024. First up, the respondent number 2 and 8 stroke NHIDCL is to submit a status report as regards the tender process initiated by the two NITs dated 28/8/2024 on the next date of listing.
For orders, item number 3.
This has to be not by my brother Sam.
Yes.
Yes. Anything, any development?
I have filed my objection yesterday.
You are representing? State. Yes, what is your instruction? And while going through, I find that by one petition, how can you transfer 3 cases? I don't know. It is permitted. Then by one petition, 100 cases may also be transferred. And also check all the Supreme Court decisions, whether this bench is not subordinate to principal bench. One civil court in one state, one civil court in another state, they are subordinated to a high court. But Kohima bench is not perhaps subordinate to. It is permanent bench. Think over it. For the time being, list the case before any other bench without one of us. Justice case Emma. When do you want? List the case immediately after.
In fact, these matters are fixed on the 24th of October for hearing, my lord.
No, this is not. This is transfer petition. If transfer is affected prior to 24, hearing may not take place. List the case on. Sixteen. I think you can take forward because you cannot pass in order. It is still passed in the every state. So to form then it is a priority of the previous. We recorded that we cannot. So now this registering. 16.
For orders, item number 4.
Same.
Is it same?
Same order.
Itulah akta FID minutes. Artinya itu क्या पढ़ो ना? Sudah tadi statement berada di mana? Itu baik.
Adjournment is available.
Please, Your Lordship.
Yes.
Your Lordship, I'd like to mention hearing item 9 and 10 on behalf of estimated senior government applicant.
9 and 10. Okay. Mr. Mohan Jamil, Learned Counsel for the petition is present. Mr. Learned State Counsel, appearing on behalf of MSS May Learned State Counsel for the respondents has made a prayer for adjournment. Puस्तक as thought for by Ms. Ram Kumar, list the cases after 2 weeks. Two, yes, okay. Yes. You are Mr.
I'm appearing on behalf of the petitioner.
Law Pongener,
Yes, my lord.
Mr. Tosi Kemjian Pongener, Learned Counsel for the petition is present. Mr. Fosego Forte, Learned Counsel for the respondent number 5. Has made a prayer for adjournment. As sought for, command list the case after 2 weeks.
So there is an interim in the amendment.
The interim order passed earlier shall continue till the next date of listening. Yes, you are there. Mr. So and State Council are present.
Please, my lord.
Yes.
Yesterday I mentioned two IAs.
Huh.
It has not been listed, but they have informed us to place the files before the Honorable Court. Though it has not been listed.
What is the prayer?
For deletion of the name of two petitioners in writ petition 190 and 194.
190.
Writ petition in writ IA in writ petition 190
Okay.
and in
Okay.
194.
Court master. Bring them by list, making a list. Okay. Bring them. But prepare. a list.
IA.
Okay.
Lodge.
It's your lordship. Lordship, I beg to make a mention for two unlisted motion, lordship, lordship, which is number is, WPC 227 and 228 of 2024 lordship. Lordship here, interim protection is, required lordship. And since the puja holiday is starting from tomorrow, so I pray that if this two matter can be taken up today.
Yeah, court master. My lord. Put it in the other ones. I've already taken up two. These two, give it to the other ones. These two, unlisted.
Lordship, right, lordship.
Yes. No, no. I can permit. I can permit or not. Or she should be mentioned. You can make a mention there. If not, then it will be listed. If that court does not permit, then this court will permit.
For motion, item number 4.
The main file, please give the main file also. Give the main file also, read petition
My
file.
lord.
Yes.
Please, Your Lordship.
Yes.
This review petition has been filed.
Hey, tell Bosumundari to come, tell Bosumundari to come.
If your worship may allow me to take your worship to the. No, I didn't say that. Petition, Your Lordship.
Hmm.
Yeah, I mean, for. Paragraph, your worship, I may be allowed to read.
Hmm. Now, this petition is filed by how many? Two.
Two of them.
Okay.
They are the respondents 44 and 45 in the WPC
Okay.
317.
317.
Yes.
44, 45.
44 and 45. And their appointment order is at 337. Next, 337.
Page? In the repetition, do you have any idea? Which page? B 37. Okay.
Page 69.
Hmm. So why did not you bring this issue when during the proceedings of the writ petition?
Yes, I have.
Huh?
I have explained it in my pleading, Your Worship. It is working back.
Hmm.
Worship, and I read from paragraph 1 onwards, Your Worship. That the circumstances. If I may read. Paragraph 1, that the petitioners herein are the respondents number 44 and 45 in the WPC number 317 of 2023, which was disposed of by the Honorable Board by Petitioner and order dated 26/9/2024, whereby inter alia the appointment of all the respondents, that is the respondent number 6045, including the petitioners herein, has been set aside and first being made without any advertisement by the state respondents, and the state respondents directly to issue advertisement of the posts and newspapers which are widely circulated in the state of Nagaland, and selection to be held in accordance with the below following the principles mentioned in articles 14 and 16 of the Constitution of India. 2. That the petitioners humbly and respectfully state that the peculiar circumstances leading to the disposal of the WPC number 317/2023 by the aforesaid judgment and order dated 26/9/2024 has been clearly emphasized and delineated by its Honorable Board in paragraph 4 and 5 of the judgment and order. Although no affidavit in opposition has been filed by the state respondents as well as the private respondents, number 6 to 45. Taking into account the clear submissions made by the learned traditional advocate general Nagaland, representing the respondent number 1, as well as Mr. Jamir learned counsel for the respondents number 2 to 5, and also by the counsel for the private respondents number 6 to 45. That the command judgment and order dated 29/2024, passed in a big batch of big petitions, WPC number 159/2022 to WPC number 199/2022, involving similar issues would also govern the WPC number 317/2023. This Honorable Board was pleased to dispose of the writ petition accordingly. 3. The petitioners humbly and respectfully beg to state that counsel representing the private respondent number 6 to 45, including the present petitioners who are the respondents number 44 and 45, made the submission before the Honorable Board that the command judgment and order dated 29/2024, passed in the WPC number 189/2022 to WPC number 199/2022, also would cover the case of all the private respondents in good faith, though erroneously, owing to miscommunication among the private respondents and the erroneous information given to the council just prior to the hearing of the case, that all their appointments were similar in nature. It may be pertinent to mention here that the counsel for the respondents had informed the private respondent to furnish him with all reports to enable him to file the affidavit in opposition. And the respondents were.
Yes, what do you say? We'll be having the records of these two out of the Jamir or Mr. Additional Advocate General. Who will have the custody of these records? Because to review the judgment, we have to be convinced. Hmm.
Now, during the pendency of 189, this present petition was filed. And the issue involved in the all petitions are same in the sense that appointment was made without advertisement. That was the issue of question. Now, the government.
No. The picture presented
No.
now.
The government has stopped Paraguay's government's productive part. And in fact, there was I sent Paraguay's government's erosion to the government. But in the meantime, I was engaged as special counsel erosion.
Hmm.
So since it was addressed to the government erosion, this was not brought to my notice. Now we are watching. So when the matter was taken up, in that view, the matter that the matter relates to making appointment or advertisement. And since the issue is already covered in the petition 159, your worship, if setting time to file affidavit in opposition, your worship, it just you like telling a delayed technique, your worship. So in that view, the matter include it. I saw that yes, 189 will cover this. So this is because miscommunication. Department said they have sent to government, okay? But in the meantime, I was engaged as special counsel. So this Paraguay community information that is why this community because of this.
Okay, who will be having the custody of these proceedings, recruitment procedure? At a later point of time. When I'll be asking to produce the records related to this recruitment process, right? To find out that whether the situation of respondent number 44 and 45 are different than the situation of the other respondents.
Yes.
So we have to bring an exception
Yes.
if his affirmation is correct.
Yes,
So who will be having the records?
your also will be.
Who will represent that respondent? That is what I have
I
asked.
understand.
Okay, okay.
And
Yes. Yes. You have made two scapegoats. Appears to be this order. Appointment order says, on having been declared successful in the recruitment test conducted by the recruitment board on 13/12/2018, following are have appointed to the post of so and so. It is there in the appointment order. Something is mentioned. Their appointment order, 7 January 2019.
Yes, Lordship.
So prima facie, it appears as on date. So the repetition was disposed of. You were on service
yes,
with a certain observations and directions at paragraph 15.
your also advertising is that right.
So in such situation, we can, have you made a statement that you are in service?
Yes, yes.
Where is that?
I have annexed all the,
No, you are in service as on date. Any
yes,
statement, where is that?
no statement as yet, but
Okay.
it is.
So we can say that I cannot set aside right now. I cannot modify the judgment. On a later date, after hearing and after getting response from your side, I can, but status quo is on today as regards their position. I cannot stay. I have to record that they are in service. No, that is there, but that was with the word may be allowed, not shall be allowed, right? May be allowed, but they have the discretion. So as on that their service, so status quo is on it. Today I cannot, review is different, repetition is different. There is already a judgment in force. So status quo as on today. Only for these two. Third, Mr. Tongpok Podjener, learned counsel for the review petitioners, two review petitioners. Post up. Also heard MS Jed Zimomi, learned counsel for the respondent number 1 to 15. Mr. L.T. Sanktam, learned additional advocate general Nagaland, along with V. Jimomi, learned government advocate Nagaland, for the respondent number 16. And Mr. T.B. Jamir, learned counsel for the respondent number 17 to 20. 17 to 20. The instant review petition is filed by two review petitioners. One, Viboto H. Shumi, and two, Kenei Sophie, seeking review of a judgment and order dated 26/9/2024, passed in a writ petition, WPC number 317/2023. Post up. Para. The writ petition, WPC number 317/2023 was preferred by 15 number of writ petitioners who are arrayed in this review petition as the respondent number 1 to 15, challenging the appointments of 37 number of
Actually, it's 14.
40 number of sub-inspector of police within bracket SI stroke unarmed branch sub-inspector of police within bracket UBSI stroke assistant sub-inspector of police within bracket ASI stroke instructor Havildar in Nagaland police by the state respondent authorities on different dates in the years 2019 and 2020, wide orders of appointments, annexed to the writ petition as Annexer B-2, Annexer B37. Full stop. The said 40 number of alleged illegal appointees were impleaded as party respondent number 6 to party respondent number 45 in the said writ petition. Full stop. The present two writ petitioners, review petitioners, were impleaded as party respondent number 44 and party respondent number 45 in the writ petition WPC number 317 2023. Poster. Para. During the writ petition came up for final consideration on 26/9/2024. And on that day, the learned counsel for the parties, including the learned counsel who represented the respondent number 44 and respondent number 45, were heard. Full stop. During the hearing, it is found that no counter affidavit was filed on behalf of any of the was filed neither by the official respondents nor by the private respondents. Post-op. It was submitted on behalf of the respondents, on behalf of both the official respondents and the private respondents, that the comprehensive affidavit filed on behalf of the state in another writ petition, in another batch of writ petition, WPC number 189/2022 to WPC number 199/2022 would govern, involving similar issues, would govern the issues, would cover the issues involved, would also cover the issues involved in the writ petition WPC number 317/2023. The primary contention advanced on behalf of the petitioners in WPC number 317/2022 was that the appointments of the respondent number 6 to respondent number 45 were made without any advertisement and without any kind of recruitment process. Full stop. Finding after hearing the parties and perusal of the materials on record, and also taking into account the judgment and order, common judgment and order, dated 20/09/2024, passed in the batch of writ petitions, WPC number 189/2022 to WPC number 199/2022, the court had found that the court had reached a finding that the appointments of the respondent number 6 to respondent number 45 were not preceded by any public advertisement and any kind of selection process. Full stop. Accordingly, consequently, the writ petition WPC number 317 What, 317?
17.
317, 2022, 23, was allowed, was disposed of with the following observations and directions, para 15. Para 15. Huh? The review petitioner's hearing. Learned counsel for the review petitioner's hearing have submitted that there was miscommunication between him and his clients, comma, that is the respondent number 44 and 45. He has submitted that though it was represented to him that their appointments were preceded by an advertisement and a recruitment process, comma, no documents supporting such fact was furnished to him at a time anterior to the date of hearing. As a result, comma, he could not represent on the date of hearing that the situation, fact situation relating to the respondent number 44 and 45, comma, that is, comma, the two review petitioners hearing were different from the fact situation obtaining as regards the appointment of the other private respondents, that is, comma, the respondent number 62, respondent number 43. Full stop. Para. Referring to the documents annexed to this petition, comma, Mr. Pongener, the review petition, comma, Mr. Pongener has submitted that the two review petitioners were appointed as, where is your appointment order?
The last page, page 43.
Were appointed as assistant to district commandant within bracket SI, case 43, and instructor Havildar respectively by an order dated 7/1/2019 passed by the Director General, comma, Home Guards and Civil Defense, Nagaland. After due advertisement, after publication of an advertisement, and after a recruitment process, full stop. Subpara. It has been averred that it has been averred in this review petition that by an advertisement was published by the Office of the Director General, comma, Home Guards and Civil Defense, Nagaland, in an English newspaper, comma, Nagaland Post, in its issue dated 4/10/2018. Annexer? Annexer,
P1.
within bracket, Annexer P1.
P1.
Inviting applications for filling up a vacancy in the post of sub-inspector and one post of Havildar inspector. Post of. It was in response to the said advertisement, the two review petitioners herein submitted their candidature. Post of. The two review petitioners were thereafter shortlisted and were asked to undergo medical test, physical test, followed by written examination and oral interview. Post of. Where is the circular dated 6/11/2018?
So here is at page 37, Annex P2.
It transfers from a circular dated 6/11/2018 of the Director General, Home Guard Civil Defense, Nagaland, annexed to this review petition as Annexer B2, 116 number of candidates were shortlisted to undergo physical test for SI and 14 number of candidates were shortlisted for undergoing physical test for Havildar. Full stop. In the said circular, the name of the two review petitioners figured, the name of the review petition number 1 figured as serial number
90.
90
90 of the first.
90 in the list shortlisted for SI, and the name of the review petition number 2 figured at serial number 6 of the list prepared for the post of Havildar. Post. The two review petitioners after were found had qualified in the physical test as well as in the medical test. Thereafter, they were declared successful in the written examination as well. Full stop. It transfers from an order dated 6/11/2018, annexed as B4, Annexer B4 to the review petition, a board was constituted for the purpose of conducting medical tests, physical tests, written tests, and oral test pursuant to the advertisement dated 4/10/2018. Full stop. After at the conclusion of the recruitment process, the two review petitioners hearing were found to have fulfilled all the parameters laid down in the selection process, and the results of the selection process was declared and published. Page 42,
Page 42.
date
Date is 16 December.
Oh. were published on 16/12/2018,
18.
and the results were also published in the English daily newspaper, Nagaland Post,
Nagaland
in
Post.
its issue dated 16/12/2018,
18.
annexure B6 bracket, wherein the names of the two petitioners were published as the recommended candidate for the post of sub-inspector and instructor Havaldar respectively. So it was thereafter, by the impugn order dated 7/1/2019, within bracket annexure B7, the two review petitioners came to be appointed by the Director General, Home Guards and Civil Defense, Nagaland. Full stop. Para. Mr. Jamir, Learned Counsel, appearing for the official respondent number 17-20, and who also appeared for the respondent number. No. In the repetition. Who also appeared for the respondent number 2 to 5 in the repetition, WBC number 317/2022, has submitted that initially he was not representing those respondents, and he was handed over the brief at a later point of time. Full stop. At the time of handing over the brief, it was instructions were placed before him. Verbal instructions. Initially verbal. No, you are verbal. It is later on you have found. I'm recording that. There has to be miscommunication. Miscommunication, you say. Verbal instructions were placed before him to the effect that the appointments, all the private respondents, the respondent number 6 to respondent number 45 were appointed in similar manner, and thus, the issue involved in the batch of writ petitions, WBC number 189/2022 to WBC number 199/2022, were same. Full stop. It was in such fact situation, he made his submissions basing on the submissions advanced by the Learned Advocate General in the said batch of writ petition. Full stop. Mr. Sanktam, Learned Additional Advocate General, Nagaland, has also submitted in similar lines as Mr. Jamir. Full stop. Mr. Jamir has further submitted that a communication was sent from the official respondents to the then government advocate who represented the respondents, who represented the respondents 2 to 5 earlier, wherein written instruction, huh? What I said? Sorry, a set of written instruction. To the earlier students. Wherein it was mentioned that the appointment of the respondent number 44 and 45 was preceded by an advertisement and a due selection process. Full stop. As the said written instruction was not handed over to him at the time of handing over the brief to represent the respondent numbers 2 to 5 in the writ petition WBC number 317/2022, he could not place the said instruction at the time of hearing of the writ petition WBC number 317/2022 on 26/9/2024. Right, is some full stop. In a sense, there appears there it is primarily due to miscommunication. He could not place the proper instruction at the time of hearing. Full stop. MS Zimomi, learned counsel for the respondent number so and so to so and so, 1 to 15, and who represented the 15 writ petitioners in the writ petition WBC number 317/2022, has fairly submitted that the instructions were placed to the effect that all the appointments challenged in the batch of writ petitions WBC number 189/2022 to WBC number 199, as well as WBC number, what was the other one? 318. 317 and 318 were all illegal, as no advertisement was ever published prior to those appointments, and no selection recruitment process was undertaken for such appointments. It was in such situation, the submissions were advanced at the time of hearing that all the appointments were illegal. Full stop. MS Zimomi has further submitted that after having a look at the annexures appended to this writ petition, it appears prima facie review petition. It appears prima facie that perhaps the appointments of the two review petitioners herein were preceded by an advertisement published in the newspaper and a selection process consisting of medical test, physical test, written test, and oral interview. Para. Having heard, I have considered the submissions of the I have given due consideration to the submissions advanced by the learned counsel for the parties, and have also gone through the statements and amendments made in this review petition, including the annexes appended to this writ petition. Full stop.
Review petition.
A review petition. Review petition is rare normally, so does not come automatically in the mind. Pusta, para. Having regard to the materials brought on record, on consideration of the materials brought on record in this review petition, it primarily appears that the appointments of the two review petitioners was preceded by an advertisement published in a English newspaper, and thereafter, the recruitment process, thereafter a recruitment process consisting of medical test, physical test, written examination, and oral interview was conducted, wherein the two review petitioners appeared to have participated. Also, they are also not in Nagaland police. That is a different directorate. Under whom, but not Nagaland police. From the appointment order dated it further transpires that the results of the recruitment process was also published in the newspaper. Full stop. Having regard to such materials, I am of the considered view that the two review petitioners have made out a prima facie case for review of the judgment and order dated 26/9/2024, insofar as the observations and directions made in respect of their appointments is concerned. Full stop. Para. Mr. Pongener and Counsel for the review petitioners, two review petitioners has submitted that the as on date, both the review petitioners are serving in their respective post. Full stop. In such view of the matter, as the two review petitioners are serving, it is observed that there shall be status quo as regards the service of the petitioner till the returnable date. He made out a privacy case corpus. Issue notice. Returnable on November 8th of November. 8th of November. I'll be sitting there. 8th of November. As so and so appeared, accepted notice, so and so. Having regard to prima facie case or petition, to issue notice, it is expected that the respondents shall make endeavor to file their respective counter affidavits on or before the returnable date. Full stop. Mr. Jamir, learned counsel representing the respondent number so and so shall make endeavor to obtain the relevant records as regards the recruitment of the two review petitioners are concerned. Only to that. Status quo. Yes.
For motion,
Boss.
item numbers 5 and 6.
Mr. Lordship,
Yes.
I
Okay, okay.
160 is for deletion.
Then give me 5 minutes.
First,
Oh, you want to see the IA?
Mr. Sankta, in review petition, is Mr. Jamir available? Can you call Mr. Jamir? One legal issue in a review petition, which is to be addressed by the council. See, in a review petition, if the review is allowed, but a review can be partly allowed. If the review is allowed, judgment is to be set aside. Whether there can be partial review. This review petition, that partial review can be done. Because if the review petition is allowed, the judgment is to be set aside. Then the writ petition is to be heard afresh. Normal situation is that. Here is partial review. So partially set as can be set as, yes, Mr. Iralu. just to come up possible, but find out some authority, because see, normally if a review petition is filed, review petition is dismissed, it is okay. Judgment stands. If the review petition is allowed, then judgment is to be set aside. And writ petition is to be heard afresh. Now here is a situation of partial review. Have you understood? Two extreme situation is that a review petition is dismissed, nothing more is to be done. Judgment stands. And if review petition is allowed, as per the judgments of and otherwise also legal provisions, then the judgment is to be set aside and the writ petition is to be heard afresh. Right? This is the two extreme situation. And it is a case of partial review. So whether partial setting aside of the judgment or modification or the alteration of the judgment is possible or not, this is a legal issue which is to be addressed with some kind of authority. I'm requesting it, don't leave the entire research to me. Don't leave the entire research to me. I request and entrusting a part of the responsibility to you as well. Because Supreme Court is clear that if review petition is to be allowed, then judgment is to be set aside. And the writ petition is to be heard afresh. Right. But here is a case of partial review. So what is to be done? How to go ahead? Have you understood? Yes, MM Jimomi. Please come with some. And also to Mr. Congener. Otherwise, it is very easy to dismiss review petition. Three parameters. No diligence shown. End of the matter. But since they have come up with some privacy materials, so I am alive to that situation and asking you to do some research how to go ahead. It is the review is allowed, then the judgment does not stand. But here is not the case. How to go ahead? In the extreme situation, the writ petition is to be heard afresh. Now here is in the middle. The whole judgment cannot be set aside. So the writ petition cannot be heard afresh. How to come out of the situation? Please.
May I proceed, Your Lordship?
Yes.
My sincere apologies for mentioning again, Lordship. Lordship, I made a mention before His Lordship. However, my prayer for taking the unlisted motion, Lordship, is not allowed. So if these two matters can be taken up after the regular matters, Lordship.
That is not allowed. What is the prayer there?
Lordship, here.
What is the extreme urgency? Tell me.
Lordship, there in WBC, in one WBC, that is 227, Lordship, there, the petitioner's license has been cancelled for the fair price regulation, which is regarding the distribution of essential commodities to the public, Lordship. And in another writ petition, that is for we are challenging the Debashi court order, Lordship, that is Debashi court order, Lordship, customary court order, that is relating to the property dispute between the husband and wife, Lordship. And the wife has occupied the said dispute, the said property, Lordship, and she's making some alteration and all in the said property. So where the interim is required, Lordship, in this two matter, Lordship. So.
Okay. List it. List it.
Much obliged, Lordship.
Yes. What is this? Yes.
Here, this IN number 160, my lord. This, if I may be allowed to withdraw this
This one.
petition, my lord, there's some clerical mistakes, my lord.
Okay.
And lordship, if I may be allowed to make another submission here, my lord. Yesterday, I submitted a mention memo for the listing of IN number 163. But inadvertently, the registry has listed 160. So since it's already listed, 160 has already been listed, I will withdraw this. But however, lordship, I have requested the registry to let me move this, the other IA also. The urgency is in the other IA, my lord, which I mentioned yesterday.
What is the
So 160, my lord, here, the writ petition number 11. One Mr. Vinny Kire, my lord, he wishes to withdraw his name from the petition. And the matter is listed on the 14th of
Okay,
October for.
Okay,
Yes,
allow,
sir.
allow. Okay, in this repetition, what to do? You want to withdraw this?
160, yes, my lord.
Miss-
IA 160.
Miss Lucinio. Learned counsel for the applicants has submitted that this she may be allowed to withdraw the instant interlocutory application. First off, you are
Respondent one.
who are the writ petitioners? You are the writ petitioner.
Yes, my lord, I'm the writ petition.
Mr.
Pictures,
Learned counsel for the respondent number
1 and 2.
1 and 2, and Mr. Learned counsel for the so and so have submitted that they have no objection if the prayer is allowed. First off, in view of the above submission made by Lucinio, the instant interlocutory application is dismissed on withdrawal.
IA 163, my lord.
This is filed in which writ petition?
Same writ petition, my lord.
Okay.
Same writ petition, 50 of 2022. So here, petitioner number 11 is from Mr. Vinny Kire. He wishes to withdraw his name from the writ petition, my lord.
Pine Kire.
Yes, my lord.
Where is the averment?
Ship, I have stated in my page number 23, my lord. That para 4, my lord, that he'll be undergoing medical treatment. Due to financial constraint, my lord, he wishes to withdraw.
Part Miss Lucinio, learned counsel for the applicant. And Mr. So-and-so, learned counsel for the respondent number so-and-so and Mr. So-and-so. Huh? The instant interlocutory application is preferred by the applicant seeking deletion of his name from the array of petitioners in the writ petition, WBC number 50/2022, wherein he is the petitioner number 65. 11.
This is petitioner number 11.
MS Lucinio has submitted that due to His personal reason, the applicant does not want to pursue the writ petition. And he may be allowed to withdraw his name as writ petition number 11 in WBC number 50/2022. Any objection? You are the counsel for the petitioner. Then you have to file amended cost title again.
Sure, I will do the next.
No objection, लिखिले. Having regard to the submissions made by the learned counsel for the applicant, that's writ petitioner number 11. And the averments, statements and averments made in this interlocutory application, this interlocutory application is allowed. Post of consequently, the name of the applicant as writ petitioner number 11 in the writ petition WBC number 50/2022 is to be deleted. Post of para. Main writ petition. Heard Miss Lucinio, learned counsel for the writ petitioners, Mr. So-and-so, learned counsel for the so-and-so, and Mr. So-and-so. In view of the order passed today in the interlocutory application IA 163
Yes, my name.
2024, Miss Lucinio, learned counsel for the writ petitioner, shall file an amended cost title within 3 working days from today
Much obliged.
on submission of the amended cost title, the registry to carry out the necessary corrections in the writ petition as well as in the CIS. Release the case after 1 week.
Here, the IA 121 is open in this court.
What is why IA 121?
This IA 121 has been prepared by the respondent for 1 and 2. For the applicant 1 and 3.
Because I have been filed by the NHID
Ah,
saying that the landowners have been obstructing. And they're unable to carry their work.
we put it on 14/14. We are not.
It's fixed on the 14th.
14th.
I can be heard together with the.
Release the case on 14th.
Judge.
We'll give consideration. We'll not have time to consider.
For motion, item number 7.
We'll issue notice at this stage after, you have come after 6 months. 15/3 to 14/3/2024.
Yes.
We'll fix a date, returnable date. And your
9/9/2024.
9/9,
9/9/2024. Annexure 2.
9/9, page 22.
Yes. This is the impugn order. This is.
What happened? What is your case? You are fair price shop owner or what?
I'm the village council chairman.
Okay,
So
So in terms of our resolution, now since 2021, the chairman has been asked to take care of this distribution of the rice under AAY scheme. Now, in the meantime, somebody must have complained as per the first annexure dated 14 March. Now, the allegation was that I have misappropriated. So the SDO
It appears from the order that it is your friends only,
Your Lordship,
members, your friends only,
it appears,
friends turning foe,
it appears,
friends turning foes.
because they are also GPs, as per my information. How far that is 100% correct, I cannot say now. But
Relevant document.
here,
As per a verification report has been furnished to you.
no report. has
No
been
report.
furnished. Not even the complaint,
Enquiry, during enquiry, anything
nothing.
was asked.
The inquiry was whether I have misappropriated. But that was by the previous SDO civil. After that, he
Right.
transferred.
Initially,
and
this
he
is
the new SDO.
14/3/2024.
Yes. At that time.
That
SDO
was, by that order, enquiry was contemplated,
Yes,
right?
yes,
Enquiry was contemplated.
yes.
Then during the later part, enquiry might have been conducted. Whether during that enquiry you were asked to so cause.
Your Lordship, there were so many people. Now,
No,
as
no.
per this order, village council members will be excluded. But despite that, there were village council members also. In that meeting, when this was rolled. And this provision, I've been denying from the beginning, categorically.
The concerned complainant
There is
and
no
the VCC is ever directed to be present with all relevant documents. Okay. And in response to this 14/3/2024, you appeared.
Yes, I appeared,
Okay.
because I wanted to clarify,
Hmm.
if there is any allegation, I wanted to clarify those. So I appeared.
Now, what is the ground of challenge?
Whether the SDO civil has the authority or has the jurisdiction to initiate this inquiry,
Hmm.
whether he has the authority or not, that is the main ground under Nagaland Food Security Rules 2016.
Which provision?
Your Lordship may see Rule 10 at page 29. Specifically, the district grievance redressal officers assigned to
Hmm.
ADC headquarters, not any other officer.
Okay.
The dual civil has no jurisdiction.
Come to page 31.
Yes,
Roman 7.
yes,
This DGRO has to pass the judgment
yes,
and clearly state in writing the reasons for his judgment.
yes.
So,
So he has to make an inquiry, take evidence, and then he has been given all the powers under the provisions of CPC.
yes, Mr. Angam. Judgment has to be delivered. 1 line, 2 line judgment cannot be done. There has to be regions
Yes.
plus authority and jurisdiction.
Yes. As per- as
One,
per-
after the inquiry, DGRO shall give his judgment,
Yes.
which shall clearly state in writing the reasons for his judgment.
Yes.
But page 22, where are the regions?
Roche, yes. As far as the inquiry part is concerned, Roche, it appears that the SGS schedule did not give it on its own, but it was on the direction issued by the deputy commissioner, which can be actually seen in the order itself. Actually. At page 21. Second line, Roche. The difference the complaint received from the members of the Ontario Village Council regarding beach management. of the
But
village and-
jurisdiction cannot be conferred
Yes,
against a statutory provision.
yes, yes. That I
And
agree.
this is an act,
Yes,
is it an act?
yes.
Rules. So rules,
In terms of the.
statutory rules.
Yes.
So ADC headquarter, he is the district grievance redressal officer designated. So jurisdiction cannot be conferred. Even Supreme Court has said, we cannot confer when this Antule case perhaps, when they transferred the case from Karnataka to someplace else. Ultimately, they realized we committed a mistake. Jurisdiction cannot be conferred against the statutory provision. It appears so.
At this stage, your notice may be issued.
Hard. But what about the,
I think that I leave it to my.
because it appears to be without jurisdiction. And it is not a judgment. Heard Mr. R. Iralu, Planet Senior Counsel, assisted by MS Etchan. Oh, you were there this side today. She's not Etchan.
No, no.
Looks similar. লিখিলো। Menociano. Learned counsel for the petitioner. And Mr. N. Angami. Learned senior government advocate for all the respondents. Close to. The petitioner is serving as the chairman of Yantamu Village Council, District Oka, which has been constituted as per the Nagaland Village and Tribal Councils Act, 1978. Close to. Para. In this petition, petitioner has entirely assailed an order dated 9/9/2024 within bracket Annexer 2 passed by the subdivisional officer within bracket C, O/O, the Deputy Commissioner Ukha, within bracket the respond number 3. First off, in the impugned order, which has been addressed to the petitioner by the impugned order, which has been addressed to the petitioner, the petitioner has been directed to return the writebacks to the allotted beneficiaries through DCSO. What is DCSO?
District Civil Supply Office.
District Civil Supply Office. as per their entitlement within 1 month from the date of issue of the direction. Full stop. Para. Learned Mr. Iralu, learned senior counsel appearing for the petitioner, has submitted that by an earlier order dated 14/3/2024, an inquiry was contemplated on receipt of an allegation, on receipt of a complaint alleging mismanagement of AAY rice in the village. Full stop. In response to the order dated 14/3/2024, the petitioner participated in an inquiry and placed his contention as regards the allegation of mismanagement of AAY rice. Full stop. It is submitted by the Mr. Yalu that the matter of distribution of rice in the state of Nagaland is regulated by the Nagaland Food Security Rules, 2016, framed under the National Food Security Act 2013, right?
Yes.
Full stop. As per the Nagaland, as per Rule 10 of the Nagaland Food Security Rules, 2016, in case of any complaint, it is only the ADC headquarter who as the designated authority, who as it is sorry, in case of any complaint for complaint, like as per Rule 10 of so and so, the ADC headquarter has been designated as the District Grievance Redressal Officer, within bracket DGRO, of his stroke her respective district, for expeditious and effective redressal of grievances of the aggrieved person in matters relating to distribution of entitled food grains. Full stop. The rules have also laid down the procedure to be followed during the inquiry by the DGRO, and after completion of inquiry, the DGRO shall give his judgment, which shall clearly state in writing the reasons for his judgment. Full stop. The submissions, the challenge to the impugned order dated 9/9/2024 are twofold. Firstly, the subdivisional officer C is not the designated DGRO under the 2016 rules, and as such, authority and jurisdiction cannot be vested on him against the 2016 rules. Semicolon. And secondly, comma, the impugn order which is been passed after an inquiry is bereft of any regions to meet the criteria of judgment laid down in Rule 10 F bracket, small bracket F, within bracket small Roman 7 of the rules 2016. Full stop. Issue notice, matter would require further consideration. Issue notice returnable in 4 weeks. Full stop. As per Rule 10 of the rules 2016, it is only the ADC headquarters who has been designated as the District Grievance Redressal Officer, DGRO, and there is no provision in the rules to vest authority and jurisdiction on any other authority to look into the grievances and for redressal of grievances. Full stop. On perusal of the impugn order dated 9/9/2024, it appears prima facie that the same does not meet the criteria laid down in Rule 10 F Roman 7 of the rules 2016. Post. In such view of the matter, comma, the operation of the impugn order dated 9/9/2024 is kept in abeyance till the returnable date.
Right.
From the supplementary post list, unlisted motion, item numbers 11 to 22.
He was there, 11 to 22. Yeah. Yes, where is MS Jimomi? Yes. IA 161, 2024.
Lordship, I
What
didn't
is
see-
it?
I beg your pardon, I didn't see that and only now I'm hearing Lordship.
Huh.
22. 22, huh?
What is the prayer here? Delete the name of petitioner number 2.
Oh, Lordship, he said 2022, so I was confused.
Huh.
Yes.
No, 11 to 22. So many items are listed, but only one IA perhaps. One 61 only. Repetition 161. Oh, sorry.
190.
194. IA 161 of
Is
2024 in WBC number 194.
194.
Ah. Yes, Chief Secretary. 。
I'm just seeking for deletion of the name of the petitioner number two. Yes, just deletion of name from the petitioner's lordship.
So it appears that in the writ petition, there are two writ petitioners. This applicant is writ petition number 2. In the writ petition, they have said that they have net qualification, petitioners. And the respondent 5 to 7 were appointed as assistant professors
5 to 17.
5 to 17,
Yes, lordship.
and they do not meet the criteria, blah, blah, blah. Now, the applicant wants to withdraw from the writ petition.
On their own, they do not meet the criteria.
No, lordship, they have passed NPSC.
No,
Yes,
the
lordship.
applicant is a writ petitioner.
Yes.
She,
Applicant is-
she does not want to pursue the writ petition. And she wants deletion of her name from the writ petition.
Because while the case was pending,
Uh-huh.
there was NPSC advertisement for the post of assistant professor.
She got selected.
And she was selected. In
She
economics.
has got her relief. Right. Let me see. Re-Sukri, when notice was issued.
Not just since I'm not actually in this matter. It is very
Go through.
difficult.
Yes, Mr. Sankam can represent, he is the additional advocate general. Nothing, deletion of her name.
Yes, nothing else.
No harm is going to be caused. In fact, one challenger has,
Since she has been selected.
And yes, lordship.
okay, heard. Only deletion, nothing more.
Only the petition, lordship.
Heard. MS Z Zimomi, learned counsel for the applicant. And Mr. Sankam, learned additional advocate general Nagaland. Representing MS V Sukri, learned additional advocate general Nagaland for the respondent number, state respondent number 1 to 4. Just hand over a
1, 2, 3, and 4.
state respondent.
State
MS
respondent.
Zimomi, if you have a copy, just hand over a copy.
Lordship, I have served yesterday, I am not here, it's not here, we have
Okay.
already served.
We have a second copy. Second copy here. Do we have a second copy? Huh? No, second copy of. Take. Okay. Okay. The instant interlocutory application. 1 to 4. The instant interlocutory application. Yes, here she comes. Okay, you hear me? The instant interlocutory application has been filed by the applicant seeking deletion of her name from the array of writ petitioners in the writ petition, WPC number 194/2023. Full stop. Para. The applicant herein as the writ petition number 2. No, sorry. The writ petition, WPC number 194/2023 is preferred by 2 writ petitioners to challenge the appointment of the private respondent number 5 to 17 as assistant professors in
Economics.
assistant professor economics in different colleges in the state of Assam,
Nagaland.
Nagaland. Full stop. The applicant herein is the writ petition number 2 in the writ petition WPC number 194/2023. Full stop. But it has been averred that during the pendency of the writ petition, the results of the selection process initiated by an advertisement dated 15/9/2023 undertaken by the Nagaland Public Service Commission were declared on 30/5/2024 and the applicants who participated in the said selection process, was declared as a selected candidate. Full stop. Thereafter, the petitioner has been appointed as an assistant professor in economics, Mount T College, TIYE College, Ukha, by notification dated 28/8/2024. Full stop. Para. It has been averred that in view of such subsequent developments, the applicant, thus writ petition number 2, does not want to pursue the writ petition seeking the relief therein and wants to withdraw her name from the writ petition. Full stop. Para. In view of such statements and averments made in this interlocutory application, the prayer made by the applicant stands allowed. The name of the petitioner, applicant, as the writ petition number 2 in WPC number 194/2023 is to be deleted. Full stop. In the writ petition, J. Jimomi for the petitioner and V. Supri, additional AG 1 to 4. In view of the order passed today in the interlocutory application IA C 161/2024, MS Jimomi 2023. No. 161. MS Jimomi, learned counsel for the petitioner, shall submit an amended cost title within a period of 3 working days from today. 3 working days. Not 3 days, 3 working days. Means it will spill over.
After the project. Obliged.
And what is 162?
This is another. 160 is also the petitioner number 1. This is in English. Yes, same.
Same deletion.
Yes, only the
Writ petition?
writ petition 119.
190.
Yes, Lordship.
Okay. Same, huh?
Same.
1 minute. Notification same.
Same.
Declaration of result same.
Same, Lordship.
Assistant professor English.
Here, English.
Respond number 5 to 12.
Yes.
And applicant is writ petition number
1.
1.
Yes, Lordship.
And her appointment in which college?
South
South,
College.
SAOCANG College.
Tuensang.
Tuensang.
Yes.
Same in the writ petition in view of the so-and-so amended cost title. 3 working days.
Lodge. Obliged, Lodge.
Anything left?
For motion, item number 24.
It's really.
Thank you, Your Lordship. My sincere apologies, Lordship. Lordship, here, the petitioner is challenging the approval letter issued by the respondent number two, cancelling the license of the fair price shop of the petitioner without issuing any notice prior to the termination, Lordship. Lordship, I have annexed the
But I am having the writ petition regarding Dubasi.
oh, my sincere apologies.
Please, Your Lordship.
This instant petition is by challenging the judgment of the date of 16/4/2024, falsified the question reporting. Simply without jurisdiction. Here, Lordship, the rest of the case is that.
No, what has been decided by Dubasi's court? What has been decided?
Lordship, let me take you to page 46, annexure N. The relevant page is at, page 49. Lordship. We are ready, Your Lordship.
Tell me, what is this story?
Your Lordship, this matter pertains to a matrimonial issue between the petitioner and the respondent number two. Your Lordship, in this case, the respondent number two fled away without the knowledge of the petitioner. And on her own record, with the excuse that the petitioner was having extradition matters. Hereafter, Your Lordship, to resolve this matrimonial issue, the petitioner approached the Gauhati village council to settle the issue as per the customs and tradition of Suminaga tribe. The respondent number two was summoned on 3 occasions. However, the respondent number two failed to turn up. In this regard, the Gauhati village council passed an order in the favor of the petitioner.
When this order was passed?
21/07/2020.
2 months back. You wait then. It is not of emergent nature. 16/4/2024. Is it not?
Yes, no, we are challenging the.
Why then at the last moment they were showing urgency? 16/4, 6 months back. List it on 14. This is not of that kind that which requires urgent relief. 16/4, you are waiting till today, October.
We received the judgment order in the month of September. The judgment order was passed without the knowledge of the petitioner and in his absence.
Where have you stated?
Page number 10, para 11.
Simply may you made a statement. How you have received them? How you have received? Pronounced in open court on 22nd March. Page 49 says. Pronounced in open court. I am not very satisfied that regarding urgency to move an unlisted motion. We put it on 14. Ivan is not going to change. List on 14 then.
Pleasure, Your Worship.
Only opinion. Huh? What? Today? Where from? Where is the hearing? Which one? Huh? Which hearing? Huh? Did I mention? Ah. No, what is late? Ah. Admission. Admission. Which one item number 1? This one. Huh? And? Okay. Plus one motion. One more motion. First, call item number 1. No, after at the end. You should have proceeded the unlisted at the last. Unlisted should have been at the last. Yes.
For admission, item number 1.
Yes.
Here are some content they want to
Hmm.
On the last petition, by the Honorable Court order dated 17/9/2024. The Honorable Court has directed the state respondent, more particularly the Commissioner, to go for verification.
Hmm.
Particularly, the respondent, they have filed interrogatory application for
Now, you were supposed to get this
no,
verification report.
verification.
Have you got it or not? Yes. Yes, Mr. Joseko.
The rephrase is that since the foundation, the base of the building, the area of the gate and the lift shaft needs to be covered. It needs some repairing at the base of the gate. So even the petitioner has a file in that. 16.
And who are the petitioners? Who are the petitioners? Ah.
Taking into account public safety, we have no objection here. But if certain time will be given, specific time will be given.
These are not legible. Better you bring a legible copy in neither of the, none of the pages. Mr. Poseco will put it after vacation.
Lordship.
Let him bring a legible copy on record. No, you bring a copy on record by a short affidavit, 1-page affidavit. So that whatever is there to be ordered to be passed, it is to be passed on the basis of records. Sending over is bit difficult because the dispute is inter-party. I think two private parties. And we will be made the scapegoat. In the eye. You are the applicant, Mr.
Lordship, I'm the legal lordship.
Mr. Poseco Pote, learned counsel for the applicant. MS, learned counsel for the opposite party number 1. And Mr. P. Jimomi. Learned government advocate for the opposite party number 2 and 3 are present. Mr. Jimomi, learned government advocate, has submitted that he has received a copy of the verification report dated 30/09/2024 from the Office of the Deputy Commissioner, Dimapur. Huh? 224. No, has received by communication dated 30/9/2024, verification report. He has received a copy of the verification report from the Office of the Deputy Commissioner by the communication dated 30/9/2024. First off. As first off. Mr. Jimomi is permitted. Mr. Jimomi shall bring the said verification report received from the Office of the Deputy Commissioner by way of a affidavit within 10 days time. 10 days or 2 weeks. And find out a better copy. And photographs should be colored. Some high courts have now passed orders that don't bring black and white because it can be subjected to manipulation. So I'll not write that. You just bring colored photograph within 2 weeks' time. As sought for by the learned counsel for the parties, leaves the case on 21st, 10. Interim order, past idly, shall continue till the next set of business. No, we need item 3. It is that item 3. Yes, what are the admissions?
For admission, item number 8.
Yes, madam. If it consumes time, then I'll post it. What is the purpose? For hearing?
No. In view of the notification, 29 September 2024, the other day that was submitted before the Honorable Court, placing the district court employees under the High Court. Now, Lordship, since that has been already done, I just want to appraise my Lordship that as per the court order dated 25/8/2020, paragraph 8, where my late husband writ petition was to be covered by the rules, the existing rules of 2017, District Court Employees Rules 2017. My husband died on 2022. Now already 2 years and 6 months.
Right, that day.
Yes, yes.
Honorable
Lord
Chief
Chief.
Justice has expressed him, wait for
Exactly.
some time, you wait for some time, he'll decide about that, this 60 or whatever pension or all this.
Yes,
That was
It has
expressed
been
to you,
processed.
that was expressed to you.
Lord Chief, of course.
This matter was also expressed because
Yes,
you
yes.
submitted that day, I was there.
Yes, Lord Chief.
So modalities will be worked out, that is what he said.
Lord Chief.
So you wait for some
Yes,
time,
ma'am.
how much?
Your lordship. The letter came up on 14/3/24. If it is that together with COP.
No.
That is already segregated.
No, that day, that separation issue
Yes,
came up before the division bench of the Honorable Chief Justice. This matter was also mentioned
Lord Chief.
by MS Jimomi.
Yes,
And
Lord Chief.
Honorable Chief Justice has expressed a view that you wait for some time.
yes.
So you wait for 2-3 weeks. Let us see how it proceeded,
Lord Chief. It has been fixed on.
because this pension issue are to be deliberated
Lord Chief.
outside the court by the Chief Justice with the state government.
Lord Chief.
So let us wait for 3 more weeks. Jimomi, Learned Counsel for the Petitioner, Sanctum, Learned Additional Advocate General, Nagaland for the respond number 1 to 3, and Mojui. Respond number 6, MS Lucino, 4 and 5 are present. Lucino, Learned Counsel, representing Mr. A. Jimomi, Learned Standing Counsel GHE for the respond number 4 and 5. You get updated status, both 4 and 5 and Mr. Sanctum, and you represent?
My role will come after the state decide.
So you are last. But you find out what is the deliberation during the interim period, interregnum, right? Do you have the notification date?
Which?
That-
Notification. Yes,
Just,
Lord Chief.
I'll just mention it and return back to you.
It's okay, Lord Chief, I have extra.
From the notification dated 29/9/2024. It transpires that the issues pertaining to the age of superannuation, pay structure, etc., would be amicably discussed between the parties. Full stop. In such period of matter, this repetition, this matter stands adjourned for 3 weeks.
Lord Chief.
Place the case after 3 weeks.
Oh, right, Lord Chief.
You can take it back.
For orders, item number 3.
Yes. Hmm.
I was attended for return of service on the bank respondents number 3. Your lordship.
5, 7, 8, 9, 10,
Yes, my lord.
16. How many?
Respondent number 3, 4, and 6, we refuse to accept.
What to do? 3, 4, and
3, 4, and 6, we refuse to accept.
whether any direction was passed to send it by register post.
Final law.
Better you take steps by register post. If there is postal endorsement, refuse. Refuse means acceptance as per law. But how can you prove it?
My lord. My lord,
You
my
take
lord,
register
my-
post.
My lord, orients the other ways, because here in the respondents, their essays are not properly written. Because that is with the available materials on record that we have sent in. So that is how I have asked for the speed. So I may develop
to take steps by way of paper publication.
That will cost you more.
But if I.
See, suppose if I go by your averments, that these three respondents have refused to accept the notice, that means the messenger had gone to their houses.
Madam,
And going to the houses, now cannot you take the plea that I don't know their proper addresses? Am I clear? In your dusty compliance affidavit, you have said that when they were sought to be served with the notice, they refused to accept the notice, meaning thereby the messenger had gone to their addresses. Now you cannot take the plea that you don't know their full addresses. How can you go?
Sending,
This is a false statement.
sending it by registered post may take more time. And this issue is with regard to a land issue. So this issue has to be settled.
Okay.
early. So I will be able to take two paper copies. I will have paper copies.
Okay. Hey, bring send for or PS, my PS more. Okay, hard, mister. They know their standard thing. Please call. I do not want to make corrections. One English, any local? No. District?
District head.
Fake. They know how to do it so that my time will be reduced. Paper publication, substituted service. Respondent number 3, 4, and 6. Widely circulated newspaper in the district of Phek. District of Phek, P-H-A-K, huh? And compliance affidavit. Huh? Heard Mr. Takakichu, learned counsel for the petitioner, Mr. Angami and Angami. Huh?
For one.
Learned state counsel for the respondent number 1 and 2. Full stop. The petitioner was permitted to serve notices upon the respondent number 3 to 11 by way of dusty, and after serving the notices by way of dusty, the petitioner was asked to file a compliance affidavit to that effect. Full stop. The petitioner has filed a compliance affidavit on 3/10/2024, stating that the notices have been duly served upon the respondent number 5, 7, 8, 9, 10, and 11. And the said respondents have acknowledged the receipt of the notice by endorsing their signatures in the notices. Full stop. The duly acknowledged notices are appended to the compliance affidavit. Full stop. In such view of the matter, the service of notice upon the respondent number 5, 7, 8, 9, 10, and 11 are treated to be served. Full stop. The petitioner in the compliance affidavit has further stated that the respondent number 3, 4, and 6 had refused to accept the notice, and therefore, the petitioner may be permitted to serve notices upon the respondent number 3, 4, and 6 in by in substituted manner by publishing it in widely circulated newspapers. Full stop. The prayer made by the learned counsel for the petitioner for service of notice upon the respondent number so and so and so and so in the substituted manner is allowed. Too widely on the the two widely circulated newspapers in the district of Hague within 3 weeks. After so and so, compliance affidavit enclosing therewith the original copies of the two newspapers within next 2 weeks thereafter. Release the case after 5 weeks. Interim. The interim order passed. Earlier shall continue. Till the next date of the thing.
From the supplementary cost list, unlisted item number 24. Last.
Yes, madam.
Yes, Sir Lordship. Lordship, here this the petitioner here is challenging the approval letter dated 18th September 2024, cancelling the fair price shop license of the petitioner by replacing by one of the respondent. Lordship. Lordship, here the brief fact of the case is that Lordship, the petitioner being bona fide resident of the Ascoto town that falls under the
Bona fide, you leave aside. Firstly, are you a license holder?
Lordship.
License holder.
Lordship.
So conditions of license are governed by which act or rule?
Lordship, there is an agreement that has been executed between the petitioner and the respondent. Lordship.
No, whether there is any order under the Essential Commodities Act.
Lordship, there is an act.
That show me that distribution of articles order
Lordship.
framed under Essential Commodities Act. We have to go by a provision, whether you have been served with so-called notices.
No, Lordship, nothing has been done.
Huh?
By we are here, Lordship. No termination or any show has been issued to the petitioner.
You are license holder of what?
As a holder of
PDS articles.
fair price shop.
Fair price shop means
Yes.
PDS article, public distribution articles.
Lordship.
Huh?
The rights.
Where is the license?
Lordship, the license is at page 27, Lordship. That was when page.
Let me look at the license first.
Lordship. Page 27, the next the particulars are on page 28, Lordship. So this was initially when it was first issued with the license, Lordship.
When?
On 1st of April 2022, Lordship. And the license was extended from time to time, Lordship.
Let us see the extension.
Lordship, the extension is at page 30, Lordship. That is valid up to 21st.
See, that is page 31. That is what I am seeing.
Yes, Lordship.
Is Essential Commodities Act.
Lordship, 18 years. So, Lordship, here in fact in the
For
license.
effective implementation of hardware diseases with the implementation employed to streamline the fair price shops and the Department of Food and Civil Supplies.
In this license, Lordship, the guidelines, there are certain terms and conditions and also the agreement has been annexed, Lordship. It's in the one booklet, Lordship. It's starting from page 29 till 51, Lordship. If I may take to the relevant portion, Lordship. Lordship, here there's.
Where is your impugn order?
Imping order is at page 52, Lordship. Annexure L. The type copy is at the next page.
Yes, Mr. Angami, page 52. Whether it is preceded by any so-called notice or notice, any kind of hearing, suppose he has been granted, or he or she, he has been granted fair price of license, and that has been renewed from time to time. And as per this page, if I have just looked at subject to correction, page 30. See, date of issue is 1st April. Para 8, para 7, para 8, valid up to 31st March 2025, right? This is a license. So it is, if it is to be cancelled, an opportunity of being heard, because it amounts to cancellation, see page 52.
Yes.
You are Vito Aomi.
That is the person. who
Hutoka,
is-
okay, Hutoka. Hutoka is replaced by Vito Aomi. So there must be an opportunity of being heard.
As far as the documents that are placed on the court as of today, Your Lordship, there's nothing to show that the opportunity of birth was there on. However, Your Lordship, the guidelines for operation, if my lord can come to page 35, there is one para at page 35. The
Yes.
first- Yeah, the first para, Your Lordship, the following instructions shall be followed strictly. One, if PS are appointed for a period of 1 year only, they can be cancelled prematurely if found contravening to the.
Right, or that they should be asked to show cause at least. It should be preceded by a notice.
Yes.
And there has to be an opportunity of being heard.
Lordship.
Then court has no, that procedural formalities is must. It is inbuilt.
Yes, yes.
Well, where is your statement? No opportunity of being heard, no notice.
Two para language. If I may, page 8.
Does not issue prior notice. He says, on note,
This may be issued, Your Lordship. As
no,
far
this should be kept in abeyance.
Lordship, as far as the interim prayer is concerned, since there is a private respondent involved, my lord.
Yes, it is expired. He will come under section, article 26(3). If he can make out a case. But it is for you to first show cause before the court that it was preceded by any notice. Otherwise, if you get a license up to 31st March 2025,
Yes.
you are sure that you'll be allowed to continue.
Correct.
Suddenly, on one fine day,
Without any short. Yes,
and his every planning goes haywire.
that I agree.
This
As of
person,
today, Your Lordship, I
person-
cannot say.
person is put in difficulty, right?
Lordship.
Sudden cancellation. This is arbitrary exercise of power. You should be given a notice at least that you have contravened this provision, please show cause. Thereafter, you Found it?
Yes.
unjustified, unacceptable, cancel. But there must be some notice. Heard. Miss
Mika actually, Your Lordship.
Mika so-and-so, learned counsel for the petitioner. And Mr. N. Angami, learned state counsel for the respondent number 1, 2, 3, 4, 1 to 6. Close to. It is the case of the petitioner that he was granted a license to run a fair price shop initially for a period of while license number, page 38 আছে লেখা আছে page 38, huh? By a license number so and so, initially for a period of 1 year from 1/4/2022 to 31/3/2023 at the locality dash Asukotu town KPA district Joneboto. Petitioner has stated that he thereafter petitioner stated that thereafter, the license was extended for a further period of 1 year from 1/4/2024 to 31/03/2025. The petitioner has claimed that he has been running his fair price shop under the license without any complaints from any corner whatsoever. But he has been suddenly served with an order dated 18/9/2024. Annexer L issued under the hand of the Director, Food and Civil Supplies, Dimapur, Nagaland, within bracket, respond number 2, whereby the said respondent has conveyed approval for replacement of the fair price shop of the petitioner by one Vito Aomi on the basis of purportedly on the basis of a feasibility report of the district civil supply officer, Juneboto, within bracket the respondent number 6. MS so-and-so learned counsel for the petitioner has submitted that the impugned order of replacement amounts to cancellation of the license of fair price shop of the petitioner, which was otherwise valid up to 31/3/2005. It has been submitted that such order of cancellation was without any kind of prior notice. The matter would require further consideration. Issue notice returnable in 4 weeks, as Mr. Pangami learned so-and-so has appeared and accepted notice on behalf of the respondent number 1 to 6, issuance of formal notice to the said respondents and dispense with extra copy by the course of the day. Both have to wait now. It is available or not? Available. Okay. During the course of the day. On perusal of the impugned order dated 18/9/2024, it appears primarily that the impugned order amounts to cancellation of the fair price shop license of the petitioner which had otherwise validity up to 31/3/2025. Full stop. The petitioner has made statement on oath that no prior notice was served upon him prior to cancellation of the fair price of license by the impugn order dated 18/9/2024. Full stop. Any order of cancellation of such before cancellation of any such license, the licensee ought to have been provided with an opportunity of being heard. Full stop. Having regard to the projection made on behalf of the petitioner, the impugn order dated so and so, shall be is kept in abeyance till the returnable date. Full stop. Oh, the petitioner shall take steps for service of notice upon the respondent number 7 by registered post-suit AD within 3 working days from today. Let him come. Meeting. No. Come. Yes.